Hey everyone, Rob Ryder, December 12th, 2012. Wow, the 26,000 year event is now down to less than two hands worth of fingers. Amazing. Don't know what it means, but we're 9 days away. Well, in case it doesn't make a big change, right? If we're all still here on the 22nd, well, then we should continue on to learn how to do a proper pleading to put into the Chancery side of the court, into the equity side. Again, common law and equity are two separate forms of law, and they're being administered by the same people. So if you want equity, you need to say equity. You need to go to equity, and it's really what they're hiding from us, although they use it against us all the time. And as you'll see, we'll be able to tell by looking at the court codes and kind of what they mean. But most everything I'm going to talk about came out of these different bench books, so forth, that are on the Michigan's court website. So if you were to just Google by your state, whatever, and look for bench book, well, you might get a list of them. I did. I want the one for the circuit court in civil proceedings. There are other books also, but here in Michigan, the circuit court is the court of general jurisdiction. So it's over law and equity. It's it's the general court. General is good, all encompassing. So I just point this out. We're not going to be reading out of these, but basically, just go do a Google search on whatever your state is, court bench book. See what comes up. Looking for civil proceedings. And the other one is, okay, I can get rid of that one now. I want to get rid of some of these things here. And then if I did another one on court rules, so Michigan court rules, and found another site that has all these different court rules listed, and in the bench book it talks about these court rules, and this is the book, Chapter 2, Civil Procedure, Michigan Court Rules of 1985. This court rules book has got like 9 different chapters, and Chapter 2 is on civil procedures, so we want to know what this has to say. And another interesting one then is Chapter 3, which is on special proceedings and actions, such as extraordinary writs, writ of quo warranto, that we talked about, or I talked about in my last video, where I showed that back in the 1850s or whenever it was when this book was written, that these were powers that were in the Chancery Court in Michigan, and now they're in the because it's a civil action, and we'll get into what that is later. These are done through the Circuit Court, which has general jurisdiction, meaning over law and equity. And Roe walked into an old county courthouse and was told, go down to a certain room, and looked above the door, and right there it said, Circuit Court. I'm not going to say it's that way everywhere, right? But it exists, right? And perseverance will find it for you. And we only need to find it in one court in all 50 states, and it'll be the same in all the states in all the counties of that state. So this is a good book too, right? So you're looking for something that has to do with special proceedings. And this has got all sorts of things here. What do we got? Oh, open it up a little bit. Claim and delivery, attachments, garnishments. You can garnish them. Capacity to sue, pleading, ex parte, temporary, and protective orders. Right? You could have a temporary order, a temporary, what do they call it? TRO, temporary restraining order, issued against pretty much anybody, such as a utility company. Tell them to stay off your property. The police department it's just a frickin' corporation. None of those people have taken a lawful oath, so there's none of them holding public office. They're a corporation. Well, they have no more rights than the guy running a fruit stand. The extraordinary writs. Proceedings involving real property. Well, we may have something to do with that kind of stuff. And then miscellaneous proceedings. Public nuisance. Arbitration. Public nuisance. Leave me alone. You're disturbing my peace. And on and on and on. So it's another good book to have. But out of that, getting down to what we can do in less than an hour. Mainly talking about pleadings, which is what they call the document that you submit to the Chancery side of the court in equity. Because all civil proceedings, right, they don't have anything to do with money. They have to do with something other than a money damage that somebody's looking for. As we just saw in the special proceedings, it shows all the other things you can get from Chancery other than money. And that's only available through Chancery or equity, whatever you want to call it. Law gives money damages. Equity gives all other types of relief, extraordinary relief. So I get lots of people that, have a controversy with saying that the deed of trust, the mortgage, the security deed, whatever they call it, where you said to the lender, you got an agreement with the lender, they're going to lend you money, you're going to make these payments, you're going to give them the title to your real property, right? Because you list what the real property is. You give them a promissory note, and then you agree to make payments. Well, the promissory note and the payments are personal property. And it's called a security agreement. Right? And I don't know why people think that just because you signed it, it's fucking lawfully binding, excuse my French, because it's not a contract. And an agreement, if it's not a contract, then you can't convey property, because contracts are used to convey property. The best it could be with your signature on it by itself is a gift, and it is not a perfected gift because they didn't acknowledge the gift. Even gifts need to be acknowledged. So in the Circuit Court Bench Book, it said contracts. The essential elements of a contract are parties competent to contract, a proper subject matter, legal consideration, mutuality of agreement, I think that means more than one person, and mutuality of obligation. Jeepers. Legal consideration, something of value given by both parties to a contract that induces them to either or to enter into the agreement to exchange mutual performances. And on a contract, the highest consideration you can give is a promise, and that's your signature. You promise to act in good faith to what the contract says. Well, you've signed it, they haven't. Right? They're not operating in good faith. They haven't signed the contract, yet they're going to use that piece of paper to say they have an equitable mortgage over the equity, which is the deed of trust. However, they can't produce, since that's the security agreement, and it's a first lien security agreement, well, the lien needs to have been recorded in the office of the recorder for the deed of trust to exist. That's what this thing to do with the master mortgage is all about. Right? If there's not a master mortgage recorded, lawfully recorded, as it says in the statute, that's right on the damn form, well, then there can't be a deed of trust. These are all things I've covered before, and as far as I know, no one's ever tried them, so I just say it one more time and move on. So what do? Commencement of action, service of process, pleadings and motions. Okay, well, this is the meat and potatoes for us because we're trying to commence something. Form of action, there is one form of action, or there's one form of action known as a civil action. A civil action is commenced by filing a complaint with a court. That's pretty self-explanatory. What's a complaint? A civil action is commenced by filing a complaint with a court. It must set forth specific factual allegations stating claim upon which relief can be granted and contain a demand for judgment. Okay? What is it you're complaining about? What's the relief you want? And demand judgment. Pretty simple. Don't tell them, well, I've been trying to make my payments and da-da-da. No. That isn't what the complaint is. The complaint is the bank hasn't signed the damn contract. Here's a copy of the recorded deed of trust as it sits now. Only I've signed it. If they have not acknowledged the deed of trust, it's not a contract. They're in breach of contract. And I want my property back. Right? Based on the preponderance of the evidence. I don't want to wait for a court date. I want you to give this to a judge, have him look at the evidence, and make a determination. That's what we're going to try to do. So we didn't do that with Rose, but she's going to go in and put in a motion asking for declaratory judgment, hopefully yet today. So that's what a complaint is. Summons, expiration of summons, dismissal, issuance. On filing of a complaint, the court clerk shall issue a summons to be served as provided. The court clerk is going to issue the summonses. You're not going to have to do anything with it except give them a complaint in the form of a pleading. And the summons must be issued in the name of the people of the state of Michigan. Well, guess what? The prosecutor just became your attorney. Because that's what he does when he puts it on there. In the name of the people of the state of Michigan. All right, if he's suing for the state of Michigan, that's what the damn paperwork says. Those are we command summons under the Great Seal, gotten from the Court of Chancery. That's why you had to go to the Court of Chancery to get that Great Seal. Otherwise, you get the private seal of the private court, which is like the 16th Judicial Court or 8th Circuit Court or some frickin' number in front of the Circuit Court. And then they have waiver or suspension of fees and costs for indigent persons. Well, an indigent person is poor. God loves the poor. Sign the paper. Do it for free. The manner of service, this has more to do with what they're going to do. This is what the clerk's doing. And here, there is no territorial limitations on the range of process issued by a Michigan court. You take it into the Court of Chancery, it can go anywhere in the world and touch somebody. That's called the long hand of the law, being used for you. So what's a pleading? Definition of a pleading. The term pleading includes only, it's either a complaint, a cross-claim, a counterclaim, a third-party complaint, an answer to a complaint, or the things above, a reply to an answer. That's all there are, but it starts with the complaint. So we can enter a complaint, but the other thing is they've, like in a foreclosure, put a complaint in against us. Well, we can go to the Court of Chancery to answer that complaint. We don't need to go to that private court where they want us to put our paperwork into the law side. Excuse me. We're going to go to the living side to Chancery to answer a complaint. No other form of pleading is allowed. That's all there is. Complaint, counterclaim, cross-claim, third-party complaint, an answer demanding a reply. Designation of cross-claim, counterclaim, a cross-claim or counterclaim may be combined with an answer. Okay, so right, you only have 5 choices. Either you're putting one in, or basically you're answering one that's been put in against you. General rules of pleading. A pleading to be concise, direct, inconsistent claims. Each allegation of pleading must be clear, concise, and direct. Inconsistent claims or defenses are not objectionable. A party may allege 2 or more statements of fact in the alternative we're in doubt about which of the statements is true. It's almost like an either or. You can allege that. State as many separate claims or defenses as a party has, regardless of consistency and whether they are based on legal or equitable grounds or on both. Doesn't matter if you're inconsistent, you just write it on paper. a statement made in a pleading are subject to the requirements of some other law or Michigan court rules, right? So it's elsewhere in this particular book. Statement of claim, a complaint, counterclaim, third-party complaint must contain the following: a statement of the facts without repetition, on which the pleader relies in stating the cause of action, with the specific allegations necessary reasonably to inform the adverse party of the nature of the claims and adverse party is called on to defend. What are you complaining about? Who are you complaining about? What is it they've done? A demand for judgment for the relief that the pleader seeks. The pleader seeks an award of money or not. A specific amount must be stated if the claim is of a sum certain or a sum that can be computed. Can by computation be made certain, or an amount sought is $25,000 or less. Otherwise, if you're not looking for money, a specific amount may not be stated, and the pleading must include allegations that show that the claim is within the jurisdiction of the court. Declaratory relief may be claimed in cases of actual controversy. That's what I want. I want a declaratory judgment. Relief in the alternative or relief of several different types may be demanded. Right? So you can demand an injunction to tell them to leave you alone. You can demand that they enforce the contract, the sales contract that you and the grantor had on the land, on the warranty deed, so that it's properly executed. Right? You want to have specific performance. You want that contract specifically executed. It's just not been completely executed. Just like the deed of trust hasn't been executed. Form of responsive pleading. So this is if you're answering back because somebody's put in a claim against you, and Lord Coke says man can answer into any court he desires. It doesn't matter where the complaint came from, how you got the complaint given to you. You can answer any place you want. So you want to go to Chancery to answer it as a pleading, as a civil action. If it says, as we'll see, they give the codes that make it a civil action. Well, that means the place to be answering is actually back into Chancery. That's where the case started. So it must state an explicit admission or denial. They send you a frickin' summons, say you deny all charges. Right? Plead no contest. Don't want to do that. Or state that the pleader lacks knowledge or information sufficient to form a belief as to the truth of the allegation, which has the effect of a denial. Right? Just tell them you haven't given me enough information for you to make a decision. I lack the knowledge. And then then they can't get away with a one-line frickin' complaint. They have to put down what the complaint is. Or just deny it. Or tell them, well, as soon as the plaintiff puts his allegation under oath, you'll answer the pleading. Allegation in a pleading that requires a responsive pleading or other than allegations amount of damage of the nature of relief demand are admitted if not denied in responsive pleading. Allegations in a pleading that requires a responsive pleading, so it requires an answer, other than allegations of the amount of damage, as far as how much it is, or nature of the relief demanded, are admitted if not denied in responsive pleading. So other than the amount or what the relief is you're asking, as far as the actual facts of the matter, right, are admitted if not denied, right? So that's why I think they want to have these pleadings. Each paragraph is supposed to be numbered. Each paragraph has just a particular fact in, and the circumstances around the fact, and then you can deny as you go through. But if you don't deny each, then they're saying it's admitted. Pleading special matters. Except to the extent required to show jurisdiction of a court, it is not necessary to allege the capacity of the party to sue, the authority of the party to sue or be sued. A party wishing to raise an issue about legal existence of a party, the capacity of a party to sue or be sued, or the authority of the party to sue or be sued in a representative capacity must do so by specific allegation, including supporting facts peculiarly within the pleader's knowledge. All right, so your answer is, by what authority are these charges brought? And you're asking for, by information in the form of quo warranto, to see that officer's oath of office to ensure that it's the one mandated by the Constitution. Otherwise, he's not holding a public office, and he's using color of law against me, a living man, and that's fraud. That's penal code fraud. Color law, penal code. You can also raise an issue about fraud, mistake, or condition of mind. In an allegation of fraud or mistake, the circumstances constituting the fraud or mistake must be stated with particularity. I don't believe that the attorney has a contract with the plaintiff. And if he doesn't, then he's misrepresented his position, and that is fraud. Or you can malice, right? A malicious prosecution, intent, knowledge, and other conditions of mind may be alleged generally. You can just say, I believe this to be a malicious prosecution. In a pleading, performance or occurrence of conditions precedent, it is sufficient to allege generally that all conditions precedent have been formed or have occurred. Well, what were the conditions precedent, performance or occurrence of conditions precedent? Well, sign the damn contract, bank. They haven't done it yet. And that is a denial of performance or occurrence, what must specifically with particularity, right? They need to sign the frickin' deed of trust, the mortgage. Action on a written instrument. In an action on a written instrument, the execution of the instrument and the handwriting of the defendant are admitted. Again, for an instrument to be executed, two parties have to be involved. Right? If nobody accepts it, well, then it didn't go to anybody. Official document or act. In a pleading of an official document or official act is sufficient to allege that the document was issued or the act done in compliance with the law. So I'm going to say an official document is a certified copy out of the deeds office that shows that, you know, in one case that you've acknowledged the warranty deed and now you want specific performance to have the warranty deed lawfully executed and the title deed put in your hand. Because again, the warranty deed is just a sales contract. We want the title deed. Excuse me. And a certified copy of the deed of trust, again, showing that only you've signed it. If you were to send the bank a letter, say, hey, you haven't signed the deed of trust, you know, you have 14 days to sign, or if you're not going to sign it, then send me back my securities. Do that under the seal of a notary. You know, you just got a notary now as a witness, and that's another official document. And you can use statutes, ordinances, charters. In pleading a statute, ordinance, municipal charter, it is sufficient to identify it without stating its substance, except as provided in some other sub-rule. Right? So, MCL, Michigan Compiled Law, you know, pick a number, 550-01, whatever it says. I don't need to put the whole thing in, apparently. I just need to reference it. It'll be by reference. Special damages. One item of special damages are claimed. They must be specifically stated. Okay. This is a good one. Law of other jurisdiction. Notice in pleadings, a party who intends to rely or raise an issue concerning the law of a state other than the state of Michigan, the United States territory, which the United States territory would be the Northwest Ordinance, a foreign nation or unit thereof, a federally recognized Indian tribe. So a foreign nation, well, that's the Vatican. They're a foreign nation. They got a thing called the Code of Canon Law in 1983, and I like Canon 204. Christ's faithful are those who, since they are incorporated into Christ through baptism, are constituted the people of God. For this reason, they participate in their own way in the priestly, prophetic, and kingly office of Christ. I'm claiming the office of Christ. They are called, each according to his or her particular condition, to exercise the mission which God entrusted to the church to fulfill in the world. God gave each of us a special gift. We're supposed to go give it away for free, and for that, everything is paid for. And go pick up some trash. All right, let's clean up the frickin' Garden of Eden. And this one's good. Notice, a party against whom a claim is asserted may give notice of claim that a non-party is wholly or partially at fault. This is when they start pointing the fingers at each other. All right, you put one of these lawyers in the holding cell for 3 hours and give him a frickin' a prison bologna sandwich, and he'll start squealing like a pig. They're weak. They can't take it. Forms of pleadings and other papers. The rules on forms, captioning, and signing. So first of all, easily to do a pleading, if you have Word, right, and you go under File, New, one of the headings is Legal Pleadings. You click on it, and they have a pleading wizard. And you just, follow the directions. So, what's it need? Well, it needs a caption. That's the main thing. Other than a caption, it's just numbered paragraphs of statements of fact. The first part of every pleading must contain a caption. The name of the court, the names of the parties, or the title of the action. So there could be a plaintiff and a respondent, but it also could be, the title could be in the matter of, and then my all capital letter name, estate. Right? That's the title of the action. Complaint. The case number, including the prefix of the year filed and the 2-letter suffix of the case code, from a list provided in the state court administrator pursuant to, according to principal subject matter of the proceedings. So they want you to put on there 2012 and a 2-letter code. And here are these codes. Maybe too big. I like AH, AP, criminal appeal is AR, civil appeal is AV. So if you were to look at, let's say you're involved in an action now that they've brought against you, it's going to have a 2-letter code in it, and this would tell you, this list, what it is you were being charged with. And from there, you would be able to define what your defense was based on the charge. And basically say that they've not given enough information to substantiate the charge. Please tell me more. I'd love to hear more. And while you're at it, put it under oath. Housing and real estate, CH. Contract, CK. Antitrust, franchising, CP. Claim and delivery, PD. And on and on and on. So, that's what this list is about. And so, that you need to put 2012 or, very soon 2013, and then the 2-letter code. Name and business, name and address, okay. And then it must contain either of these. Number one, there is no other pleading or resolve civil action arising out of the transaction or occurrence alleged in the complaint, or a civil action between these parties. So this is like if you're being foreclosed on, a civil action between these parties or other parties arising out of the transaction or occurrence alleged in the complaint has been previously filed in, right? What court's on your frickin' on your foreclosure case? What's the docket number? Who is this assigned to? This is showing you that you can answer back in to any court you want. You didn't have to go to the court that issued the civil action. You can go to the court you want to, and we want to go to the Court of Chancery, which is the equity side of the general jurisdiction court. In Michigan, the circuit court. But not the 8th Circuit Court, just circuit court. In a complaint, the title of the action must include the names of all parties with plaintiff's name placed first. So really this, it's just a cookbook. Take your time, go through it, figure out what we need, how you got to sign it, what happens if you don't sign it. Summary disposition. The judgment on stipulated facts. The parties to a civil action may submit an agreed upon stipulation on facts to the court. If the parties have to the facts sufficient to enable the court to render judgment in the action, the court shall do so. A motion. A party may move for dismissal on a judgment on all or part of a claim. A motion under this rule may be filed at any time consistent with Subrule D, but the hearing on the motion brought by the party asserting the claim shall not take place until at least 28 days after opposing party has served with pleading stating the claim. Disposition by court, immediate trial. A court may, under proper circumstances, order immediate trial to resolve any disputed issues of fact, and judgment may be entered forthwith if the proofs show that the party entitled to judgment on the facts as determined by the court. So, again, I have full proof evidence, certified copies of that I've acknowledged the warranty deed and that I've revoked the deed of trust by showing him that the deed of trust has not been signed by the bank. Breach of contract. And let the judge decide. Now, if there's already an action pending against you, then you're doing a motion. An application to the court for an order in a pending action must be by motion. Unless made during a hearing or trial, a motion must be in writing, state with particularity the grounds and authority on which it is based, state the relief or order sought, so always what is you're looking for. And what you're always looking for is to get your property back. Right? I want my property given back to me. Or I want a temporary restraining order against somebody so they leave you alone. That somebody could be the tax man. They can't prove why they can come and take your stuff. Well, then leave me alone. Parties, plaintiff, and defendant. Real party of interest in an action must be prosecuted in the name of the real party of interest. The capacity to sue or be sued. A natural person may sue or be sued in his or her name. And then a person conducting a business under a name subject to certification under the assumed named statute may be sued in that name in an action arising out of the conduct of that business. Now, this is interesting. They say your real name is your surname coupled with your first and second. Right? So surname, comma, leave a space, first, second, or given name. Let's call it the given name. That's your real name. Well, if you write your name first, middle, last, you're doing business under an assumed name. If you put it in all capital letters, first, middle, last, you're doing it under an assumed name. And so you need to be, you're supposed to have a certificate showing you're doing business under an assumed name. Talked about this in an earlier video. And but they're showing that that you can sue in that name or be sued in that name. A domestic or foreign corporation may be sued or be sued in its corporate name unless statute provides otherwise. Unknown parties. Persons who are or may be interested in subject matter of any action, but whose names cannot be asserted or diligent inquiry may be made parties by being described as unknown claimants, unknown owners, unknown heirs, devisees, or assignees of deceased person who may have been interested in the subject matter of the action. Okay, so you don't need to know everybody. You just say you don't know who they are. Okay. A person desiring to appear and show his or her interest in the subject matter of an action must proceed under another rule. Subject to this rule, the person may be made a party in his or her proper name. I got to go see what proper name is now. There's another form of name. Remember, name itself is the root word, and anytime you add something to it, you've just diminished its singularity or its strength. It's a derivative of name, right? So proper name is a derivative of name. So is legal name. So is given name, surname, on and on. Now, Michigan, they have a thing called the Court of Claims, and it has a particular jurisdiction, and the Court of Claims is in the circuit court in the county where the state capital is, and the state capital is Lansing, and I believe it's Ingham County. So that's where the Court of Claims is. It has exclusive jurisdiction where a complaint seeks relief against the state or its agencies for either money damages or equitable or declaratory relief. So I think if you're doing a pleading, it's not that you couldn't put it into your county to get it into the circuit court. You would just, is the court is going to, is the Court of Claims. And it would be for money damages or other kinds of relief against the state or its agencies. It is the nature of the claim, not the type of relief sought, that determines. A claim must be either ex contru or ex contractu or ex delicto. Ex delicto is defined as a tort, fault, crime, or malfeasance. But this would be against state officers, and again, we don't have too many state officers. We do have state agencies. So, if you were going to go against a state agency, you would put it into the Court of Claims as a civil proceeding on a pleading. And the name and form of the court would be the Court of Claims. In contrast, the term ex contractu, it describes civil actions arising out of a contract. And it encompassing quasi-contracts, which is any contract. A quasi-contract is when only you've signed it. That's a quasi-contract. An implied contract, an adhesion contract, whatever it is they're going to try to pin on you, it's a quasi-contract. It means it's not a contract. Arising from contracts implied in fact and law. Okay, they're just implied. And the only reason they can imply it is because you haven't rebutted it. In addition to exclusive jurisdiction over contract and tort claims seeking only declaratory relief, the Court of Claims also has concurrent jurisdiction over complaints seeking declaratory and equitable relief not based on tort or contract. So again, this has to do with against the state, right? Not against a person. These are against the state. Most of ours are against a person. Either it's a natural person or a legal person, as corporations are legal persons. And then we had different Michigan Court of Appeals jurisdiction. And actually, the Michigan Court of Appeals, forget the name, I believe it's actually the Supreme Court. Small s Supreme Court. The big S Supreme Court, Michigan Supreme Court, I believe is the same as the House of Lords, the Judicial House of Lords in England. And those judges are chosen by the people in the House of Lords. Well, here in Michigan, the Chief Justice of the Supreme Court, the candidates are picked by the parties, the National or Democratic Party. They're really being chosen by the House of Lords. You may get to vote on them, but I really wonder how many Supreme Court justices have anybody running against them. Right? That's just a sham, right? They're actually picked by the House of Lords. Okay, and then that Circuit Court Bench book, we talked about the contracts already. Declaratory judgments. The court's power to enter a declaratory judgment. Any Michigan court of record may entertain a declaratory judgment. Circuit district probate courts have jurisdiction in any case in which they would have jurisdiction if other relief was sought. So you need to go to the correct court. And so to me, it's just better to go to the circuit court because they have general jurisdiction over everything. The circuit court's going to decide what court will hear it from there. As far as I'm concerned, they're going to the chief judge is going to assign the case to whatever court it would go to. Actual controversy required. There must be an actual controversy that causes a party to seek declaration of rights or legal relationship. Excellent. Do I have a contract with the bank or not? Yes or no? I want a declaratory judgment. And if, based on the preponderance of the evidence, you say I don't have a contract with them, well, then I want my frickin' property back. Actual controversy exists for the purposes of a declaratory judgment where the plaintiff pleads and proves facts demonstrating an adverse interest necessitating a judgment to preserve the plaintiff's legal rights. Show them the evidence. You can have expedited hearings. If a declaratory relief is the only relief sought, the court may order expedited hearing. Once a declaratory judgment has determined the rights of the parties, any appropriate relief may be granted, including monetary damages. So looking at this all over again, we should just be asking for a declaratory judgment based on the facts. Not necessarily I don't want to see the attorney's contract. I want to make it based on the facts, based on the evidence that I'm bringing in with my petition, or pleading as they call it. Right? That here's a copy of the warranty deed, and I've acknowledged it. I want to have specific performance on this, and here's the deed of trust that they haven't acknowledged. I suggest you write them a letter and say you got 2 weeks to acknowledge it, or if they don't send you back your securities, you're going to take them to court. Well, now you are, and do that under the seal of a notary. Okay, so that's just kind of a quickie on where we're at, what we're working on now, but we need to be doing civil actions and by civil proceedings, asking for equitable remedy, not for money damages, not saying we're trying to make our payments, none of this other stuff. Right? We're going to bring forward the facts that a unilateral contract, anything that only you have signed, is not lawfully binding, and anything that you've been coerced into signing by like a cop on the side of the road, because when he takes you to court, he's trying to get specific performance on a contract. He's got your name on a contract. On that one, you both signed it. Right? And he's trying to get specific performance. He's come to equity with unclean hands. Right? So we would be using equitable defenses in that case. But we'll work through the process as we go. And that's all I got. We'll see y'all later.